The claimant, interested party and the claimant in 2479 of 2016 pray for the application for review to be dismissed with court. I've considered the averments and submissions of all the parties herein. I set down the issues that this court is determining as follows. Number one, whether this court has jurisdiction to hear this application for review, the applicants having already preferred an appeal at the Court of Appeal. Number two, if the answer to number one above is yes, whether the contempt of Court Act 2016 apply to this application. Number three, if the answer to two above is no, which law then applies? 4, whether the applicants have met the threshold for the grant of orders sought. And number 5, which orders to grant in the circumstances. On the first issue, this court draws its jurisdiction from Article 162(2) of the Kenya Constitution 2010 and Section 12 of the ELRC Act, which states that the court has jurisdiction to handle any matter relating to employment and labor relations. Under Section 16 of the ELRC Act, this court also has jurisdiction to review its own judgments, awards, orders, and decrees in accordance with the rules. The rules referred to herein are the Employment and Labor Relations Court Procedure Rules 2016, where Rule 33 of this rule states as follows. A person who is aggrieved by a decree or an order from which an appeal is allowed but for which no appeal is preferred or from which no appeal is allowed may within reasonable time apply for a review of the judgment of the ruling. A. If there is discovery of new and important matter or evidence which after the exercise of due diligence was not within the knowledge of that person or could not be produced by that person at that time when the decree was passed or the order made. B. On account of some mistake or error apparent on the face of the record. C. If the judgment or ruling requires clarification. Or D. For any other sufficient reason. These rules are couched in similar terms as Order 45 Rule 1 of the Civil Procedure Rules, which state as follows. Any person considering himself aggrieved A. by a decree or an order from which an appeal is allowed, but from which no appeal has been preferred, or B. by a decree or an order from which no appeal is hereby allowed, and who, from the discovery of new and important matter or evidence, which after the exercise of due diligence was not within their knowledge or could not be produced by him at the time when the decree was passed or the order made, or on account of some mistake or error apparent in the face of the record, or for any other sufficient reason, desires to obtain a review of the decree or order, may apply for a review of the judgment to the court which passed the decree or made the order without unreasonable delay. A party who is not appealing from a decree or order may apply for a review of judgment, notwithstanding the pendency of appeal by some other party, except where the grounds of such appeal is common to the applicant and the appellant, and when being the respondent, he can present to the appellate court the case on which he applies for the review. From these rules, it's apparent that an application for review may be preferred if an appeal is not being considered, or where an appeal is not allowed. In the case of the applicants herein, however, this court has already been notified that they have filed an appeal at the Court of Appeal, and at the same time they have filed for review, which in my view is tantamount to forum shopping. This was the holding in the Court of Appeal case of William Karani and 47 others Supra, where the court found that once an appeal has been taken, the review cannot proceed, and the issue ought to be remedied by the review must be merged in the appeal. On the second issue, the court has already determined that it has inherent powers to review its own judgments and orders as provided for under the LRC Act 2016 and even the Civil Procedure Act. This inherent power of review was tested and applied in the case of High Court Civil Case number 45 of 2008 Machakos, where the Honorable Justice Atari Waweru considered an application for review in a contempt matter and dismissed it, as there were no valid reason to warrant the review. This same power of review is not ousted by the new Contempt of Court Act 2016. However, the Contempt of Court Act, having come in force on 13th of January 2017, will not apply in this case, as the contemnors were sentenced by this court on 12th of January 2017, and the new act cannot act retrospectively. Under Section 9(2) of Cap 2, Interpretation and General Statutes Act, if it is enacted in the Act or in any other written law that the Act or any provision of thereof shall come or be deemed to have come into operation on some other day, the Act, or as the case may be, that provision shall come and be deemed to have come into operation accordingly. In this case, therefore, the contempt of Act 2016, it came in force as stated therein on 13th of January 2017, and so cannot apply retrospectively. This also answers my issue number 3 above. Given that I've answered issue number 1 above in the negative, it will be superfluous to go and answer issue number 4 above. Nonetheless, I will answer the question by stating that considering the parameter to be applied in declining whether to allow a review or not, the applicants must demonstrate to court that there is discovery of new and important matter which was not in their knowledge before, or that there is an error apparent on the face of the record, or that the ruling requires some clarification or interpretation of sufficient cause. The applicants have demonstrated to court they have not demonstrated to court any new and compelling issue or pointed out any mistake or error apparent on the record, nor any sufficient cause that will warrant review of these court orders. Indeed, they have submitted that they are engaging in the negotiations ordered by court on 1st December 2016, but they have not explained why they chose to obey part of the order and fail as officials of Kenya Medical Practitioner and Dentist Union to call off the strike as ordered by the same court. Indeed, they have also found their inability to call off the strike, which they themselves called on. It is this court's finding that there is no sufficient reason why the court should review its order, and therefore this court declines to review its orders sentencing the applicants to 1 month jail term, and the orders of this court will now crystallize. Those are the orders of this court. So, I've finished. I think I'm functioned as official. Negotiations may proceed. The Court of Appeal may proceed and make any other determinations on the issue. But you can now start serving the sentences. Those are the orders of the court.
A ruling by Justice Helen Wasilwa telling the CBA 7 or the officials of the Kenya Medical Practitioners and Dentists Union to start serving their sentence. She has listened to all the submissions, and the day is finally here, the day that the court has been waiting for. We can see them there on one end of your screen, the union officials just being cuffed so that they can start serving their sentence in different parts of this country, in different recreational facilities in this country. We see them there, the officials just being cuffed so that they can be directed now. They are, from now to the next 1 month, they will be guests of the state. They will be serving their sentence from different correctional facilities, and we're seeing the officers there just taking control. I see Titus Odoro, who is the union treasurer there, just lifting up his hands, his already cuffed hands, and we can see from the dock there the likes of Secretary General Oluga Oma also heading to just wear the cuffs. Evelyn Chege, it seems that the ladies have not been cuffed here. They're not posing any risks. And that has been quite a morning here at the Milimani Commercial Courts. We're seeing the Doctors Union officials going to start serving their sentence today. It has been quite a protracted court battle, I must say. We have been here 3 times. The suspension on this particular case has been pushed forward, but now the Lady Justice Helen Wasilwa decided that today is going to be the day that they start serving their sentence. And outside the Milimani courts, the doctors are chanting and just making all manner of noises, saying that they are going to be saying that they want the CBA implemented. They're listening to nothing else apart from the CBA, and we're seeing them there, and we'll be expecting the officials to just come out of this particular courtroom any time from now, and they will be telling us, not the officials but rather their legal representation to come out, and they will be telling us what exactly has taken place here, and how they're feeling basically about the whole idea of having to start serving their sentence